First of all, you needed to have looked at the ministers, how panicky they were. Their conduct was unprecedented in the history of Parliament. That you have Bahat picking the bill, throwing it on the table, then another minister brings a certificate of financial implication, then Oboth walks in, and he doesn't even know the rule under which he is tabling. So that level of panic tells you that the ministers moving this bill, they themselves don't believe in it. But they are on an assignment by Museveni and his son that they must try civilian, because none of these ministers is safe. That's why earlier I told Parliament, Muhoozi has insulted Lieutenant General Erweru. He has dismissed the Minister of Defense himself. He has also dismissed the Minister for Internal Affairs, former CDF David Muhoozi. So, if you didn't know, you need now to know that the Constitution has been overthrown. We now have family rule, and because you have the elder, the head of the family is grown old, so he's ruling through his son. And these ministers, one by one, I can tell you, I was in this Parliament when they brought the Public Order Management Act. I protested. Olanya ordered policemen to drag me out of Parliament. Amama Mbabazi, the Prime Minister, wanted me taken to the Disciplinary Committee of Parliament. Thank God, Amama was the very first person to be arrested under that law by Kawesi in Jinja. So these ministers who are bringing this law because today they can speak and laugh with Museveni, one by one will become victims, because you have a man who heads the military now, is swearing, insulting everybody, threatening everybody, including those who are serving in the military. So the victims who are opponents, who are supporters, Dr. Besigye and others, yes, they will continue being victims, but even those that are preparing this law and bringing it on behalf of those who are in power, they will themselves be victims of this law. Disciplinary cases of the military, but they can't become courts. All the cases, because you see, Jamiru Mukulu, who is accused of forming a rebel group and heading it in DRC, is before the High Court. But Besigye was before a military court that they found him with 2 bullets. Because the military itself has been overthrown. Muhoozi Kainerugaba runs this military, even a kiosk, you respect it if you are running a kiosk. So they are not seeking to address issues raised by the Constitutional Court, by the Supreme Court. They are trying to tactfully restore military courts, but claiming that the Supreme Court allowed them. The Supreme Court said military people cannot try civilians, because the most fundamental issue that was raised by the Supreme Court is that these people work under command. Whether a lawyer becomes, as long as you're a military man, it doesn't matter whether you're a lawyer, you will still be appointed by the high command. So you can't have a court appointed by the high command and the charges preferred against you by the high command, and then you pretend to be a judge. That's what the Supreme Court attempted to address, and they are not addressing it even in this draft. There has been an attempt. The debate by Museveni was that the court martial should be at the level of high court. And that's why they are, in their draft, they are speaking about a parent court. They are not talking about the rank of the, because you see, they said to be a chairman of the General Court Martial, you need to be at the rank of the High Court. I think the attempt is to equate the High Court with the General Court Martial, and maybe subsequently equate the Court Martial appeal to Court of Appeal. Because the whole idea of establishing military courts is to defeat justice before courts of law that are going to follow some procedures. That's why when Besigye's matter was transferred to the normal court, up to now they have no evidence, but in military court they wanted to try him in 1 week and convict him. Because in military court, whether the court is chaired by a lawyer, whether it is chaired by a judge, you are going to remain a soldier subordinate to and listening and implementing command of the high command. Nti babaka ba parliament wana abalimuko amagezi niwe gabaga kitundu. Buli omu ateeka okulwanyisa etteeka lino nga talirwanyisa ku lwa muntu mulala wabula alirwanyisa ku lulwe. Otherwise, Museveni talina mukwano, alinga mpologoma enjala bwe muluma mulinaanye gwalya. Constitution egamba tosobola kuyisa Parliament esobola kuleeta kiteeso n'ekiyisa ekisazaamu ebintu bya kkooti byesazeewo. Katubalinze batubuulire kuba wano olabye Speaker takkiriza kwogera kuteeka speed ne wabadde nga tewaliwo alireeta mu Parliament nga yeetegesedde oddiwolereza. Speaker yasoose okuwolereza etteeka kimenya amateeka nga this is straightforward matter. Yagisomye ddi amanyi nti straightforward?
Well, we should recall that there was a bill for an amendment of the UPDF Act that was before this Parliament. That bill had thought to make provisions for improvement in the medical treatment, medical services of the members of the armed forces. It had made provision for restructuring of the UPDF, I mean command and control. It had provided for some welfare for the veterans. But then amid it, the court made some judgment, and the executive thought that they should withdraw that bill to incorporate some of the pronouncement made by court. I thought that was a very wrong procedure in the first place, because now it jeopardizes the good aspects of the original amendment, which was solely to enhance the welfare of the members of the UPDF. By now bringing in the provisions of the trial of civilians before the court, I think it makes the bill a bit uglier, and it may cause unnecessary tensions in Parliament. If I were to advise, I would have isolated the issues that are purely to deal with the welfare, the structure, the command, the treatment, the pensions of the UPDF separately, and then study further how best to deal with the pronouncements of court. Now, the first fault line that I see is that courts do not make law, they just interpret. So for the executive to come with and say that we are operationally the orders of court in the law, I think that is wrong. The court may make orders, but that order is limited to a particular set of facts or cases brought before them. Now we have so many civilians who are due for trial, different from the Honorable's case. So you cannot pick the orders of that particular case, that set of facts, and then you think you can now make a law to apply to all other situations. That is the first fault line. So if the executive had sought guidance from a number of legal professionals, and even maybe the court itself behind, they wouldn't have brought this. But now that they have brought it, as Parliament, we are under obligation, under constitutional duty, to entertain proposals for legislation from the executive, look through them, accept the ones that we think it's good, modify the ones that think needs improvement, and reject outright the ones that we think does not augur well for our democracy and rule of law. I think the Speaker is maybe under pressure or under tensions, but we are guided by rules. So the pronouncement of the speakers that are in breach of the rules do not guide the House. So we cannot process the bill using the personal whims of the Speaker, the presiding officer. That is completely wrong. The rules of procedures and the Constitution are clear on how bills are processed. If the Speaker thinks the bill needs to be processed, I was waiting for her to chair the committee to process the bill, because that's the only way she can do it herself, which will be a breach itself. But if you want the committee to process the bill, it must follow the rules. And we have 45 days. It can be extended. We need to consult as wide as possible. We need to reach all the stakeholders in this country, and the position of the country is what we should provide in the law.
Is it possible to have the court-martial as an independent court?
I am hesitant, and I think it was a mistake to use the word court. It is important to have a disciplinary unit in any administration. In the army, there must be some form of disciplinary unit which is supposed to deal with offenses that are within the army. For example, if a soldier is deployed and then the soldier runs away, he has not abandoned, but because he fears to be killed, he abandons the battlefield and comes back. That soldier should undergo some kind of punishment within the mechanisms of the army. Now that is different from a situation where a soldier has committed an offense of murder. The offense of murder is triable before the civilian courts. And because it is a criminal offense, the other one could be a service offense, it could be an administrative offense to run away from the battlefield. But when it is a criminal offense, the standards are higher, and you must be tried by an impartial judge. So that person cannot be the one making the accusation. So in this case, the army cannot be the one accusing you of running away. And then the army is the same person coming to provide evidence, prosecute you. And then on one side, it is also the army, the soldier seated to make a decision on the case. That will violate the Constitution. Circumstance at all, not even zero chance that there is the civilian must be tried before the army court or the army discipline. No circumstance at all. So for me, the issue of saying we are trying to close one eye, why should you even be looking for exceptional circumstances? That tells you already. That tells you already. The moment you start saying, I'm looking through to find out, then it means there is a problem, and that should not be encouraged. Our courts instead, the civilian courts, can be strengthened. They can be given all the resources to competently and try any case in a speedy manner.
Proposed amendment to the UPDF Act is very problematic. Problematic because government is seeking to contravene Article 92. Article 92 provides that you cannot legislate with the intention of upsetting a court decision. That cannot happen. That's what they are trying to do. But you see, because of their shabbiness, one, they were not even too sure what they were tabling. The minister who was meant to table was not present. They hijacked another one of trade. He's not too sure what he's doing. Then the other one eventually came, Minister of State for Veteran Affairs, tabling no certificate of financial implications. Then the minister himself eventually comes. And by the way, the certificate of financial implication that he has tabled is defective. And I want to implore you to look for it. It is defective in every sense of it. So it's because for them, at the back of their mind is just go and make sure civilians get tried by military courts. So you can break whatever law, you can try and make it as snappy as you possibly can. That's what is happening. I really do hope that some colleagues in the NRM will come to their senses to know that this is not just for the opposition. Paul Akamba is a member of parliament belonging to the NRM. He was granted bail by a court of competent jurisdiction, and within court precincts, he was abducted, taken to no one knew for a couple of days, including his family. But he belongs to the NRM. I don't know what's wrong with these people's heads to imagine that these things will only affect, that breakage of the rule of law affects only opposition. No, it affects everybody. I'm hoping that in the next couple of days, as this bill is being dealt with and processed by the committees, I hope our colleagues will come to their senses.
So, what are the most controversial? You had an opportunity of looking at the bill. What are those controversial clauses that are upsetting you?
Number one, the Supreme Court made it succinctly clear civilians have no place being tried by military courts. These people are reintroducing that to make it legal for civilians to be tried by military courts. Number two, and by the way, the biggest beneficiaries of the Supreme Court ruling were military persons, UPDF officers. We meet a number of them and they tell us we are very happy about the ruling of the Supreme Court and so on. Please fight to see that the law doesn't come to happen, because many of them were being hounded using the military courts. Your boss is annoyed with you, he takes you to the court martial. And you see, for them, they cannot even speak out. There is no voice for them. So they were suffering quietly. And the Supreme Court said, even those offenses which are committed, allegedly, by serving officers, they are triable within the courts, the civilian courts. If it is murder, for example, that a UPDF officer has gotten his gun and he has shot at people and killed them, that is murder which is triable by the High Court. It's not, it is wrong for government to now say, we are passing a vote of no confidence in the civilian courts. The Supreme Court was saying all of those offenses are triable by the civilian courts. So what the Supreme Court said is the military courts should just be disciplinary committees to try service offenses. That this particular officer normally comes late to work, doesn't report to duty on time. You take him to the disciplinary court, the military court. This officer is insubordinate against his superiors and so on and so forth. Those simple matters get to be dealt with by the military courts as disciplinary courts. But for any other offenses which are provided for in the Penal Code Act, those should be tried within the civilian courts. And that's the issue. That's the crux of the matter. So, one, they are breaking the law. Number two, of course, we have also heard they want to fast track this. The Speaker has said, these are straightforward amendments and so on. Our committee should process them very quickly. What is the hurry about? If what you're doing is okay, why are you trying to hurry the process and so on? Why do you not want the entire process to be handled, views to be captured from members of the public, civil society, and so on and so forth, so that the entire legislative process gets to happen? One is that the military courts have been used to persecute members of the opposition. We have some young men, Yasin Machete, Kalanzi, and several others, who have been held in jail for over 4 years. Why? They are saying, you people were found with some bullets, rounds of ammunition. And for over 4 years, trial has not kicked off. They have been denied bail, and they are held in court there. So this court has been used as a tool to persecute the opposition. Those that are against the government, the sitting government, they will find something, plant it on you. We saw what happened in Arua, in Honorable Chagulanyi's hotel room. They planted guns there, and then they said, he's the one who was in possession of these guns. To this date, we don't know where those guns disappeared to. So it is a tool that they will use, that they keep using, and that's our concern. You know, that they can plant anything on you, or even pretend that this thing was found in your house. They'll raid you and say, we are doing a search here. They will lock you up in one of the rooms, and they say, we are now searching the entire house. And then at the end of the day, they come out and say, we have found this pistol. We have found these rounds of ammunition, things which they came with and they planted there. That is the concern. And that's why we are saying, let the civilian courts get to operate. You see, the other ridiculous thing that they are trying to do is that a civilian who is gotten in concert, allegedly committing an offense with serving military officers, that at the start of trial in the military court, this civilian will now be given the rank of private. Can you imagine? That all of a sudden now, you civilian, they have installed a rank of private on you. So you are now a military officer. Where in the world does this kind of nonsense get to happen? Olunaku olwaleero tulabye nga gavumenti baleeta ebbago okuleeta ennongosereza mu tteeka lya UPDF Act. Twawalabula wano kubanga bwe nabyogerako nti ababaka aba NRM n'abamu ku opposition abakolagana ne NRM baweereddwa miliyoni 10,000 buli omu. Sookera ddala okubeebaza okuyisa etteeka ly'emmwanyi. Ekyokubiri nga etteeka ly'ennongosereza mu UPDF Act ligenda kuleetebwa nga babagamba nti kakati mweteeketeeke etteeka eryo liyitewo mangu. Liirino balireese. Era ababaka abamu balaba bakyamuukiridde kubanga baagala kuwa accountability ya miliyoni 10,000 ezaabaweebwa. Naye mu kavuyo ke mulabyawo nga ne minisita alina okuleeta etteeka lino taliiwo. Waliwo gwe bafunyewo awo Bahati owa trade nga ne byasoma tabitegeera. Omu ku baminisita ba defense, minister of state azze nga talina na certificate of financial implication. Oboth bwazze minisita ye kennyini ne certificate of financial implication gyatebulizaawo nkyamu nfu. Era bwe munaaginoonyerezaako mujja girabanga nfu, tekkirizibwa mu mateeka. Kwegamba buli kimu olaba nti bakola speed kubanga bamanyi kye bakola kikyamu. Speaker Muwulidde agambye nti kakati etteeka lino liri straightforward, committee mwanguye. Lwaki obanguya? Bwe muba nga kimukola si kikyamu, lwaki temwagala processes zonna zitambule nga bwe zirina okubeera? Abantu bajje ng'etteeka lyonna bwe liba nga libagibwa bawe endowooza zaabwe ku tteeka lino. Lwaki mwagala okubiddusa speed? Biki bye mugezaako okukweka? Naye of course bye bagezaako okukweka bamanyi nti kye bakola kimenya amateeka. Ssemateeka yaffe akawaayiro namba 92 kagamba toyinza kuyisa tteeka ng'ogezaako kuggyawo kkooti kyesazeewo. Kkooti ensukkulumu yavaayo n'egamba nti abantu ba bulijjo tebalina twalibwa mu kkooti z'amagye. N'ekyokubiri n'egamba nti ne bano ab'amagye abasirikale nabo bw'abanga ateeberezebwa okuzza omusango oba asse abantu ng'akozesa emmundu ye naki, egyo emisango gyonna kkooti za bulijjo ziwozesa emisango gino. Era kkooti ensukkulumu n'evaayo n'egamba nti zino military courts zirina kubeera just nga bw'olaba disciplinary committee. Buli kitongole kibeera ne disciplinary committee. Abantu abakozi abakyuka leeti ku mirimu, abatawa bakama baabwe kitiibwa, obusongasonga obutono. Naye ensonga eziri criminal zitwalibwa mu kkooti z'amagye. Kakati zino military codes zina kuba nti kakati ono omusirikale tasalutinga bakama be, ono omusirikale atukaleeti, bamuwa obuvunaanyizibwa obw'okukola tabutuukiriza. Awo be mutwale eri mu court martial mu disciplinary committee eyo. N'emisango gino emirala gyonna kirina kubeera mu kooti za bulijjo kubanga Penal Code Act ezirambika bulungi. Naye bano bagezaako kukyanguya. Kansuubira nti bannaffe naddala abali mu NRM banaakozesa emitwe gyabwe ne bamanya nti etteeka lisobola okukosa omuntu yenna. Bayinza okulowooza nti kakati bo bali seefu ng'aba NRM, naye nkyo ojja kunyiiza muhoozi akutwaleyo mu kooti martial newankubadde oli wa NRM. Muze mumulaba General Elweru yali deputy CDF era wa NRM nga bwe muze mubalaba. Muhoozi yagamba oyo bafuuni oyo talina magezi, n'abalala bazaayogerako mu NRM. Kati gwe wa NRM ojja kukyamuukirira oyise etteeka eryo enkya n'otamanya nti lijja kukosa. Waliwo omubaka wano bamuyita Paul Akamba wa NRM, kooti yamutaka kalukaayo naye yali tannafuluma ne kooti n'awambibwa okumala ennaku famire temanyiwa waali naki. Ebyo bize bikolebwa kufa opposition, naye n'owa NRM kyamutuukako. Katusubire nti banaakozesa emitwe gyabwe ne bamanya nti etteeka ekyamu likosa buli muntu. Etteeka lino era n'obuwaayiro obulimu ffe kye tusinga okuwakanya, kubanga kooti z'amagye zize zikozesebwa okutulugunya abantu abatawagira gavumenti eno. Nti ono awakanya gavumenti nga bwe mwalaba Honorable Kyagulanyi yali mu Arua ne bakwata emundu ne baziteeka mu kisenge kye ne bagamba nti zino emundu yabadde nazo tumutwala mu kooti martial. Of course eventually byabatabukako n'emundu kati tumanyi wawe zaalaga, naye bajja kikozesa, bazze bakikozesa ne baga nti kakati abantu bano abantu 30 babasanze n'essasi limu ne bajja mu nnyumba yo gwe opposition oba omuntu yenna gavumenti gwe tayagala nti katugenda kukolako saaki. Beebuzaabuze bagambe nti wano tusanzeewo pisto batusanzeewo essasi limu, ate nga beebazze nalyo bakutwale mu court martial. Court martial eyo tulina abantu abamazeyo emyaka n'ebisiibo, Bayasini Machete, Bakalanzi n'abalala. Myaka ena bagenda mu myaka 5 tebawozesebwanga, obujulizi tebuleetebwanga. Naye olw'okubanga gavumenti kooti z'amagye zikozesa okutulugunya abantu kijanguyira, kyovudula baffe tugamba nti nedda tutambule ku kiri kooti ensukkulumu kye yasalawo. Abantu ba bulijjo n'ab'amagye by the way batwalibwe bw'abanga azizza omusango okutali gino simanya ebya discipline ki, batwalibwe mu kooti eza bulijjo kubanga amateeka weegali kiki batya abantu bano. General Muhoozi effujjo lyazaakola n'okumenya amateeka ebintu ebyo tebinnagwa by the way, tebinnaba. Era mulabye bwe mbyogeddeko wali kubanga General Muhoozi ye akolera ddala buli kimenya amateeka n'abalaga nti mulina kye mugenda mukola kubanga mwana wa mukulu. Ababaka wano yagenda aba committee ya defense n'abayita nti abo ba crowns tebali mu makulu. Era mbadde mbuuza speaker kubanga bw'oba okulembera crowns oyo abanga agamba nti goli chief crown, lwaki ebintu bino mmwe tebibanyiiza mu ababaka be bayita ba crowns naki? Mwalaba engeri gye yakwatamu eri mutwe amutute mu basement ali mu mukubakuba eno tumunoonya tewali amanyiwa waali mbuye ali mu muyigiriza Lunyankole. Mbyogeddeko awo Minister Norbert Mao kubanga ennaku zino tugenda tumuteeka kazito tugamba gwe weyita opposition tubulire ku nsonga zino. IMC n'agamba nti mu ggwanga lino tewali ali waggulu w'amateeka n'atuula n'ensonga tagizzeemu mu bulambulukufu. Era neŋŋamba nti kakati bw'oba ogamba nti teri ali waggulu w'amateeka, General Muhoozi byazaakola bimenya amateeka, ng'omukozi wa gavumenti mugenda mukolako ng'amateeka bwe gagamba n'asirika. Prime Minister ayingiddewo naye nembimubuuza neyeebuzaabuza omutwe omulabye ng'aguteeka wansi nga ayagala kwebuzaabuza nga atawulidde kyembuuzizza. Speaker n'adduka misinde ku nsonga endala. Eno ensonga tennaggwa era tujja gikomyawo kubanga bwe kisigala nga kitambula bwe kiti. Muhoozi kati ajja kukwata omuntu agambe n'okugamba kati muteekeko kamera akwate pisto amukuba essasi nga buli omu alaba ku kamera nga tewali kimukolebwako kubanga bino byazaakola. Bwe bisigala nga bitambula bwe biti nga tewali kimukolebwako, enkeera ajja kukola n'ekisingawo kubanga ye alaba ali waggulu w'amateeka.
The UPDF Act is an act within the laws of Uganda, so that one has no problem. But the big problem is that the court martial, as it is, was outlawed by the Supreme Court of Uganda. And as you know, it has been used as a conduit of trying people who are saying or doing politics sometimes which is right, but which the government would rather not hear. So it is going to be used to oppress the people, especially politicians, who say something, who call for accountability, who call for rule of law, who call for respect of rights of Ugandans. And to me, I don't know who this rule will affect next, but I am sure that even the people who will pass it, especially from NRM, if they pass it the way it is, it will affect them in one way or another. So for me, I think it's a very unfortunate way of amending this act just by inserting court martial. But what people should know, that there is a coup within Museveni's government which has been taking place. And now, as you can see, his son can arrest, which is not police, but he can arrest. He can make his own law, and he acts with impunity. And he can even promote the soldiers within UPDF. Under normal circumstances, he's not the commander-in-chief under the constitution of Uganda. But you see now he promotes under the pretext that he has given a rank under as an acting rank, or like a major general, they give you a rank which is acting major general. So you can see he has taken over judiciary. He's doing the work of the cabinet. In parliament here, we cannot even summon him. What he needs is to complete this is just to get a court where he will be someone, he will be putting people and aligning people in this court and completing him as another force, which is different from the state. I think the pressure is, I don't care, because I know there is always numbers here who really can pass anything, even if they are sleeping, as they have already said. So whether it is brought tomorrow or after 2 weeks, what I mind about as Kamara is to be on the side of history, of people who have the voice of reason. And for me, I'm against the amendment of UPDF Act to just add the court martial, which I know is going to be put to oppress the opposition, to oppress the people who call for accountability, to oppress the people who call for rule of law, and also oppress the people who call for human rights violations, who are against human rights violations of the government. And what would be important is for court martial to be trying only soldiers, because we have enough rules in our statute books. That would be the most important. The moment you go beyond, and the experience that we have got under the court martial does not give any confidence to any Ugandan that this is a law which is made in good faith. And that is the reason why I am against it.